law professor and Bruen test critic Jake Charles on the Supreme Court's first application of that test in Rahimi. That and more on this episode of the Weekly Reload Podcast.
No, the devil's got no hold on me.
All right, welcome, ladies and gentlemen, to another episode of the Weekly Reload Podcast. I'm your host, Stephen Gutowski. I'm also a CNN contributor and the founder of thereload.com, where you can head over and sign up for our free newsletter today if you want to keep up to date with what's going on with guns in America. This week's episode is once again brought to you by The Dispatch, a publication that I really enjoy and subscribe to myself, which I will tell you a bit more about at the end of the show. But before we get to that, the meat of our episode today is going to once again turn to the Supreme Court's decision in Rahimi, the first case where they have applied their new Second Amendment test, which means, it's one worth taking a lot of time to examine and try to get some of the implications from. And, on this show, we like to try and bring you guys a variety of perspectives on this. We had David Kopel on a couple of weeks ago, 2 weeks back, to give his point of view. He's a prominent pro-Second Amendment, pro-gun scholar who's supportive of the Bruen decision, that Second Amendment test I just mentioned. And we got his view of how Rahimi came down. This week, we are going to get somebody who has been a critic of the Bruen test and who's also seems to some of his writing has been influential in this decision as well, just like Kopel's was on the majority opinion. And that is Associate Professor of Pepperdine University's Law School, Jake Charles, and he's joining us today. Welcome back to the show, Jake. Thanks for coming on.
Thanks for having me, Stephen. Happy to be here.
Yeah, and can you just tell people a little bit more about your background before we get going?
Sure. So I got into firearms law by being the inaugural executive director of the Duke Center for Firearms Law. It was about 5 years ago when I started there, and it was at a good time because it was when the new justices started coming on the court and we first started getting more Supreme Court interest in these cases. So I've written a bunch of things about the Second Amendment and how the court's deciding these cases. And then I'm also working on a Second Amendment casebook with some of the folks there.
Right. And we've had you on the show before a number of times, or I think more than once at least, hopefully. I have to go back. We've done, I think, like 165 episodes now, so it's hard to keep track of every single one. But I know you've been on before, and you're somebody that I think is a prominent voice in this conversation, and who has also been somebody who's tracked a lot of the actual practical fallout from the Bruen decision. You've been the one that's been keeping track of the numbers across all these different lower court cases that have been impacted by this new Second Amendment test. And so your work has been widely cited. And one thing that you've focused in on oftentimes in critiquing the Bruen test, the Bruen ruling, is this concept of that has come up in Rahimi as well. And so I want to start with that. And it deals with how the court views founding era law or really the lack of founding era law on specific topics, and how that should be interpreted in regards to modern gun regulations. Can you just explain your view on this a bit, what the court held and why you think it's problematic, and then we'll get into what they said in Rahimi.
Yeah, certainly. So I think on one reading of what the Bruen test was doing, the reading that Justice Thomas, who authored Bruen, ends up saying is the right reading in Rahimi. On one reading of the Bruen test, what the court is requiring the government to do in cases where the Second Amendment is implicated is to produce a regulation from the founding era or very close to the founding era to support a modern regulation. And if it can't do that, then the modern law is unconstitutional. And so what that means is that if you look in the past and you see conduct that went unregulated or just the absence of regulation, then the assumption is that that tells us something about what the constitutional authority was at the founding era. And I think that assumption is unwarranted. Justice Barrett, in her concurrence in Rahimi, says this assumption is unwarranted because we can think of lots of reasons why founding era legislators might not have enacted a law, even if they thought it was constitutional to do so. But unless you assume that the only reason they did not enact the law was because they thought it was unconstitutional, then the lack of a law there doesn't tell you anything, or at least doesn't tell you much about whether or not a similar law today would be constitutional. So that kind of absence in the past And some lower courts applying Bruen's test had also adopted this reading of Bruen that it requires a regulation or a showing of statutory authority. And if there wasn't that, then the modern law was unconstitutional. I think this is one of the key fights over the justices in the Rahimi case.
Right. And this has been something you've written extensively about since the Bruen decision was handed down 2 years ago. And like you just mentioned there, it does seem like perhaps the justices have been at least reading some of your critiques, or at least this concept generally. I don't think Barrett didn't specifically reference your work, but it didn't. Right. Justice Jackson, is that?
Justice Jackson cited an amicus brief I'd done with a few other law professors that was focusing on the lower court fallout from the Bruen decision and the kind of inconsistent decisions that the courts were reaching over this and other questions like how to apply Bruen's test.
Right. Okay. So just to establish that your work has been read by these justices and seems to have had some impact here. Now, can you get a little bit more into what Barrett said, into her concurrence, and what you think that might mean for the balance of the court on Second Amendment cases going forward?
Yeah, sure. So your listeners don't need any background on what the majority said, but just to recap it so I can put her comments in context. So the majority's decision, as I read it in Rahimi, is really narrow. Essentially, the court says there's this one historical principle, and that historical principle fits basically 922G8C1 and maybe some other laws, but not a ton of other laws. It doesn't say that's the only historical principle it finds, but it says, like, we found this historical principle. You can disarm people who have shown to be a credible threat to the physical safety of others after a judicial finding. Right. So it's a really narrow historical principle. Exactly. Yeah. And I think part of the very narrowness of the majority's decision is that there's 8 justices that signed on to it. They don't all agree about the scope of what set of historical principles might justify other laws. So we've got a lot of concurrences. I counted 7 different justices out of the 9 justices who wrote separately, who wrote something in the Rahimi decision. And one of those concurrences was Justice Barrett's. I think the thrust of her concurrence was to say later tradition can't change the original meaning of the constitutional text, and only the original meaning controls. So even if we found a later tradition that was widespread and it was widely seen to be constitutional, if it's a later tradition, it can't trump the original public meaning. But in the course of doing that, she also fleshes out these ways to understand what the original public meaning is. And she rejects this reading of Bruen that would say, if you don't find specific laws, that means it's unconstitutional today. Instead, she adopts kind of this principles-based approach to looking at what she calls original history or original contours. And she says we have to look at the evidence of what kind of principles they would have understood the Second Amendment to be consistent with, not try to find particular laws. Sometimes those laws can shed light on those principles, and sometimes those regulations are what give rise to the principles. But we look for the principles. We don't look for particular regulations.
Yeah, and it is interesting in the context of some of your critiques of Bruen here, because it feels like, especially with her concurrence and Kavanaugh and the majority opinion itself, that the conservatives outside of Thomas, and we'll get to Thomas in a little bit, because I feel like you might have a similar view of his, similar view to his of how this might all come out, or what it does to Bruen. But the other conservatives on the court seem to be more in this idea of that you don't need a historical twin. It feels like she's kind of saying you don't need to have literal restraining orders at the founding for the restraining orders that affected Rahimi to be constitutional today. She's not necessarily saying you don't need any sort of evidence that this was that this type of act would have been appropriate under the Second Amendment. You just don't need a literal exact copy of the law. That, this is one of the main issues that they argue about in Bruen over and over again, right? Throughout the concurrences, at least, is this concept of like, we haven't given a lot of answers on,
Yeah.
because they set this standard of you don't need a historical twin, but also this isn't a regulatory blank check.
Yes.
And so you're supposed to fall somewhere in the middle of that. And it feels like they're going to just need a lot of time to go through and flesh out this test. And
no, she says you don't even need a cousin. It doesn't have to be a cousin. So no, we don't need twins. We don't need cousins. But yes, regulatory blank check is on the bad side, and we're kind of trying to figure out where we are.
Yeah. And so what was your main takeaway from the majority opinion in the case? It sounds like you think it was pretty narrow. What impacts do you think it's going to have on those lower courts?
Yeah. So I thought it was significant that it was an 8-1 decision. I thought after argument, most of us who heard argument thought the government was going to win. And the question was, what was the margin of victory that the government was going to have in that case? Was it going to be 9-0? Was it going to be 8-1? Was it going to be 7-2? The fact that Justice Alito and Justice Gorsuch signed on to the opinion, I think was significant. The fact that Justice Thomas did not, though, and that he was the author of Bruen, I think really suggests some internal grappling of the justices who themselves signed on to the Bruen decision about just how that test was supposed to work, how that opinion was supposed to be understood. So I got from the majority's opinion that they really didn't want to give, or maybe they couldn't with 8 justice majority, give a lot of guidance for other kinds of cases going forward. Although they wanted to correct a few of the errors that lower courts have been making after Bruen. One of those is to demand too much specificity in the historical record, to try to find too close a match for historical regulations. They said the Fifth Circuit did that wrong. They seem to suggest that lower courts were misunderstanding that. And then relevant, I think, to this case and maybe a few others, they talked about the standard for facial challenges and how the Fifth Circuit misunderstood or misapplied the standard for facial challenges, which requires the challenger to show that this law is unconstitutional in all of its applications, as opposed to maybe permissibly constitutional in some applications, even if there are other applications that might be problematic. So those are the things that fall to the Fifth Circuit for. Maybe some of those have broader echoes, but I think for me, I was maybe a little bit surprised at how narrow the decision was, especially because the court acknowledges lower courts misunderstanding Bruen. I thought we'd get a little bit more guideposts on how to address at least other questions related to permissible disarmament schemes, and particularly the other challenges that the court has already pending for the felon in possession cases. And beyond the kind of principles-based approach, namely telling courts to look to historical principles and not require exact matches to historical regulations, beyond that, I'm not sure how much guidance it gives to resolving felon in possession cases. And so I could see, for instance, if the court was to say vacate and remand the pending petitions in those cases, the 922G1 cases, I could see each of the courts that have split already on this question issuing basically the same opinions again and saying, like, we don't think Rahimi calls into question our reasoning. Their reasoning, of course, is the exact opposite, but I could see each of those courts reaching the exact same decisions, even under Rahimi.
Yeah, I think that makes a lot of sense. I mean, the court just didn't, beyond establishing that, like you said, very narrow principle of disarming temporarily people who have been shown to be a physical danger to others. It doesn't really do much else other than just sort of critique the Fifth Circuit for being too strict in how it interpreted Bruen, but it doesn't get into a whole lot of degree into how they were too strict. It just says, we found these were the laws to put together. They represent a tradition that this restraining order ban falls into.
Yes.
So yeah, I mean, and like I said, I think there's the concurrences kind of got to that point. It does seem like if you read like Gorsuch or Jackson's concurrence, they talk a lot about what the court didn't decide.
Yes. Yeah.
Right. And so there's still so many questions, even on this specific federal law, there remain a lot of questions, even for potentially Rahimi himself. because Gorsuch talks about the due process challenge. This wasn't resolving potential due process issues with the restraining order that he was disarmed under, or what have you. I don't know.
I think it's probably too late for him to raise a due process challenge, but yes, someone in his position for sure.
Yeah, so it seemed like there were quite a lot of still viable challenges, even to the very law that they were ruling on.
Yeah. Not only did they not resolve a category of cases, which is one of many categories of cases in Second Amendment world, but they didn't even resolve all the challenges to this particular law. And that's exactly right.
Yeah. But at the same time, it does give us our first insight into how this test should be done. Yes. And our first insight into it is one where the court comes down against a more conservative court's strict interpretation of Bruen. And that's what Thomas got into in his dissent. I'm interested in your view as somebody who's has been critical of the Bruen test itself. Do you, like, Thomas has a pretty dark view of where this is going to lead for the Bruen test. He kind of is at least predicting that it could potentially undermine the whole concept and the Second Amendment generally. Now, I imagine you don't agree with his view on that part, but do you take his points about how wide-reaching the way the court came to this conclusion could be? That sort of combining surety laws and affray laws to make a principle when I guess his critique was that neither one of them was really a good. Yeah. Like, what do you say? What do you think of the Thomas dissent?
Yeah. I think it's really interesting how forceful his dissent is about the majority's. I think he says that they try to rewrite the court's precedent. He certainly thinks that it is not like a different reading of Bruen, but in fact, like, if not a repudiation of Bruen, at least like a rewriting of Bruen. He thinks this isn't one kind of permissible style of implementing the Bruen test. And, I think I said something like this on Twitter earlier. I think his view of Bruen is a really narrow view of the test, but it also is basically the dominant view among lower courts, or it had been the dominant view among lower courts before the Supreme Court intervened in Rahimi. There had been some courts that had done kind of the principled stuff or raised up the level of generality a little bit, but lots of courts were reading the Bruen decision how Thomas read the Bruen decision, which is to say, we got to find a historical regulation. We're going to require the parties to put together a spreadsheet, right? Show us all the laws that existed between, maybe 1750 and 1805, right? If you compile that spreadsheet, I will pick out an individual law and I will compare that law to the modern law. This is what courts were actually doing in Second Amendment cases, based on this reading of Bruen that Thomas says, like, yes, that's what I meant when I wrote the Bruen decision. And the other justices say, that's not the right way. That's not the right way to read Bruen. So I think in terms of like Justice Thomas's dissent, he's right in the sense that that's the dominant way that other courts were understanding his test too. That's how I understood it when I was critiquing it. And the majority, I think, is maybe not reading my critiques, but reading the critiques of that reading of Bruen and saying, like, that can't be what we mean. It just doesn't make sense to say you have to have such a narrow comparison to a modern law, especially as the concurrences were fleshing out, because that's not what originalism requires when we're looking at the original scope of the right. In terms of Thomas's concern about the mixing and matching, I don't share his view that like that's, undermines like the Second Amendment if you can mix and match, because I think that the principles-based approach seems right if one is an originalist and thinks that history has to control contemporary adjudication. Then it has to be the case that we're looking not for a single particular law for all the reasons that Justice Barrett said and for all the reasons I've written about and others have written about. But we're looking for what was the original understanding of the scope of the Second Amendment at the time. That shouldn't turn on whether one particular law matches both the how and the why, right? Maybe you don't want to say like we can draw too many different kinds of laws together and pick principles and shove them together from too many different kinds of laws. But historical evidence that evinces a principle is what we're looking for. And even the Bruen understanding of relevant similarity and these metrics, they're all trying to get at like what was the original understanding. And so I think he makes too much of focusing on like these two metrics that we gave, the how and the why, as themselves like the end point, as opposed to as themselves like a sign of what the original kind of scope of understanding was.
So when he says essentially that because of the way they, especially the affray laws, the going armed to the terror of the public laws, that because people could be imprisoned for that, that implies that their guns could be removed at least temporarily.
Right.
That's sort of where the majority comes down on how they're relevantly similar. But he argues that, well, that's too broad of a reading, because you could say anything that had a potential punishment of jail time, or like if you don't repay a fine, you'd end up in jail too. So he sort of says this goes so broad that you could pick out any laws. I imagine you don't agree with his critique on that.
Well, I think maybe that's one critique of the court's like discussion of the penalty, but the penalty was only one aspect of the majority's discussion of the comparability of the burden. They also talk about that it's time limited in nature. Like that's something that's would stand apart. Like the felon prohibitor is permanent. So that stands apart already. So it's not the case that just because you have going armed laws that justified imprisonment, that everything else is automatically justified, because the penalty is only one aspect of the burden. So they talk about the time limited. They talk about that the fact that it's an individualized determination. So it's not a categorical basis, like again, distinguishing the felon prohibitor. So I just think that the majority had other reasons why it's comparable that were beyond just the fact that imprisonment was provided for in those historical laws and the modern law. So I don't think the roof is falling nature of Thomas's point on that particular provision is kind of persuasive.
And that does seem like what the other conservatives thought in response to Thomas's dissent. But it does sound like you perhaps agree with him to some point that the initial test appeared to me much stricter than how they've applied it in this case. Is that fair to say?
Yeah, I think I would say that there were a couple of ways to read Bruen when it came down, and judging by who the author was and what his expressed views in the Second Amendment are, many of us read it to say, well, that seems to require a really strict approach, a really narrow approach. A broader approach is consistent with what the court said in Bruen, but the narrowest approach was probably the best reading of what he meant, expressed in his own words in Rahimi. And so that's why a lot of people took the test to mean it's got to be strictly applied, and it's got to be narrow historical analogies. And so even folks who were argued within the Bruen framework weren't saying people would make arguments, right? Well, some will be, or most of them will be within the Bruen framework. So litigants were not asking the court to overrule Bruen. They were saying like there's this alternative reading of Bruen. And I think that's what the majority was adopting, an alternative reading of Bruen that, I think at the end of the day, we can debate how much that is a rewriting of Bruen and how much of it is just an alternative reading of Bruen. Right. If we, held their feet to the fire, what would, the Chief Justice or Justice Alito, who signed on to Bruen, say about whether or not it's a rewriting or a, alternative reading of Bruen? At the end of the day, it doesn't matter, right? But I think it's an interesting point to debate whether or not, this is a repudiation or rewriting of Bruen or just an adoption of an alternative reading of Bruen. But I do think it's the case that Thomas is right about what the dominant interpretation of his opinion was before Rahimi.
Interesting. Yeah, because Bruen itself had that concurrence from Roberts and Kavanaugh. Yeah, that implied that, or basically, it said that permitting regimes for concealed carry are constitutional as long as they're, shall issue instead of may issue, or as long as there isn't too much government official discretion involved, which they did without, going through the test of showing historical analogs for that kind of permitting. So I think there are probably signs that not everyone on the court was of the most narrow view of the Bruen test.
Yeah. And as you know, like shall issue laws post-date may issue laws, right? So they're not even like older in form than may issue.
Yeah, I think in Bruen, Roberts had a quote of like, some permitting is okay, but permitting is some permitting is different than other permitting is kind of what he was getting at. He was I believe there's like a First Amendment context to what his point was, but he obviously saw a pretty stark distinction between may issue and shall issue gun carry permitting, and that made it into that concurrence without this sort of historical, even the principles, even this justification.
And they repeated Heller's safe harbor without, to justify that.
Yeah, there's been a lot of stuff in Heller that is just kind of, we still think these things are constitutional. We're not going to, without giving you the full, doing the full work of showing why under these tests they would be. So, it's not necessarily out of total left field to see a majority come down this way.
I do think one more thing on Thomas's opinion, that there was this question after Bruen of why didn't Bruen repeat this Heller safe harbor, the presumptively lawful, felon prohibitor or mental illness prohibitions, because there's that concurrence in Bruen by two of the justices who are necessary to the majority, where they repeat it. McDonald repeated it, and Bruen didn't. And I think we see in Rahimi where Justice Thomas is in dissent, and he says, like, this is dicta, right? Like, we're not bound by this. So I think he didn't put it in Bruen because he doesn't believe it, right? He doesn't think these things are presumptively lawful.
Well, they were dicta, right? I mean, it's true, but the question being, even though they're dicta, how many members of the court are willing to vote to toss out felon in possession laws? And look, I still think that you probably have a majority that are willing to toss out some felon in possession crime. We'll see on that.
Maybe,
point, right? You got
probably.
I mean, range seems like. It just seems like this is very good litigating on the part of the Solicitor General, for one. I mean, having the first Bruen case heard be Rahimi, where the defendant is extremely unsympathetic. And, this case where the first time they're commenting on, the first time they're applying it beyond Bruen is a case where they're upholding a conviction for gun possession is what the government wanted. I mean, they didn't get what they were asking for in their brief necessarily, this sort of responsible citizen sort of standard that they had initially asked for, but they did get a ruling, like you mentioned, that basically says the Fifth Circuit applied Bruen too strictly. And I think what gun rights advocates would want to see after this, perhaps to alleviate some of those concerns that Thomas raised, is a kind of anti-Rahimi case where they do the opposite, right? They take a case.
Yeah, maybe Range would be that case.
Well, even Range wouldn't fit though, right? Because Range, the lower court ruled in favor of Range, so they wouldn't be repudiating them for being too broad. Maybe right. You'd have to take like a hardware ban case, probably. The Illinois assault weapons bans or something like that.
Yeah.
But I don't know. Do you see them doing, where do you see it going from here? I mean, the DOJ has requested a bunch of these felon in possession cases. They usually get some sort of preferential treatment when it comes to having cases granted.
I think that was significant that the government renewed its request for the court to review the felon in possession ones. It even has a footnote that says, like, look, we have other pending petitions in the C2 cases, and we have pending petitions about unlawful drug users. We're not asking you to review those now. Like, send those back down. That's fine. But we are asking you to review the felon in possession cases because that's the most heavily enforced federal gun law. And so we need clarity on this because the circuit split's going to continue even after Rahimi.
And that does go to your point about it being narrow too, right? Yes. Even the DOJ seems to think this was not giving them a whole lot to go off of.
I think that's right. Yes. So I think I could see the court taking up those cases, especially as you said, with DOJ asking them to do so. I don't know. Maybe the assault weapons are next. Maybe the sensitive places are next. Yeah, I think sensitive places, assault weapons, and the felon cases are kind of the big ones where lower courts are sort of adrift at how to apply Bruen to those kind of frameworks. And so if the court took like a where case like sensitive places, it could enunciate some principles for where you can restrict guns and where you can't. If it took the assault weapons case, it could talk about some of the principles they use for weapons prohibitions. And then if it did range, one of the benefits of having a case like range versus one of the ones that strikes it down is that the court could uphold it, but it could give a little bit more guidance about kind of how you do the framework, because it has already taken a case from the Fifth Circuit to reverse. And so in this case, it could kind of step back and say, look, when you're applying it to unlawful drug users or mental illness, like here's what you do in people-based prohibition cases.
Yeah.
That'd be
Sort of a
one
carrot and
benefit of
stick.
range.
Carrot and stick approach, I guess.
Yeah. And I mean, range itself, it wouldn't be reversal if the court agreed with the range decision, but the standard that the Third Circuit gave in range was non-existent. It basically said you can't prohibit guns from, quote, someone like range. And so even there weren't kind of principles that lower courts could apply, and so it would give the Supreme Court a chance to kind of flesh that out more.
Yeah, I mean, ultimately, do you think it just comes down to them having to take a lot more? I mean, that's kind of what Kavanaugh got at with his concurrence, where he's like, this is the Second Amendment law is comparatively in its infancy. When you look at First Amendment law or Fourth Amendment law, Fifth Amendment, all these other Bill of Rights aspects have hundreds of cases where the court has flushed out what they mean, how to do the tests, all this stuff. And we have, 5-6 cases on the Second Amendment the court's done. So you think it's just part of that? It's sort of growing pains?
Yeah, I think it's part of that. I think part of one thing that makes it a little bit different is that, we only had the couple of cases, but we had this 12-year stretch where we hear basically nothing from the court, right? And so there was this time where lots of lower court precedent was developing that is now kind of back to square one. And I think that makes it a little bit more incumbent on the court to provide greater guidance than resolving one case at a time. Because we don't get more cases that have to be relitigated after the court says, actually, you applied it wrongly again. Like now go back to the drawing board. And because it's in its infancy, I think it is beneficial for the court to move slowly, not to have like one case to say, this is how you resolve every one of these challenges. But you could do it category by category and still give guidance about how to resolve cases in that category. That's narrow. It's still, resolving some small set of claims, but it's not just like Rahimi, where the court is saying, okay, this one particular subdivision of this one particular law is constitutional. We're not going to say what else that means for other cases. I think it's got to do a little bit more than that so that we don't get more confusion and disagreement in the lower courts. And I think that's probably right. They are going to take more cases.
Do you see, so this was a scenario where you had the liberals join most of the conservatives in the majority in upholding a federal gun law.
Yeah.
Could you see them doing the same in a case where they're striking down one? I mean, is that even a realistic option? I mean, the liberals in the case still seem pretty unhappy about Bruen or even Heller to begin with. Like, how do you think?
I could see some kind of compromise in, like, if you take the Second Circuit's Antoniuk case about sensitive places, the majority there upheld almost all the sensitive places. I think maybe all the sensitive places that were challenged. But it struck down the changing the default carry rule on private property, or on private property open to the public, at least, where New York State had flipped the rule to say that you have to get permission to carry on private property. Even the appellate panel there said, that's unconstitutional, not consistent with history. Maybe there's a way in which the liberals would join on like a split decision like that, striking down some aspects of a law and upholding other aspects of a law. I'm not sure that. Caetano. Where there were no noted dissents. Maybe there's a case like that comes up. That's possible too.
but it still seems like although I guess Sotomayor's concurrence, right, did there was some hay made, I think, in pro-gun circles about her sort of accepting Heller and Bruen as the ruling standards. What was your takeaway from that? What do you think of it?
Yeah, I think like as a practical matter, they know it's not going to be overturned anytime soon. And so they're spending whatever capital they have on the court to try to bring colleagues closer over to their view rather than trying to fight a battle that they know is not going to be won for, if they even believe it, for a very, very long time. I don't know. I mean, it
didn't seem like Jackson was trying to do that.
Yeah, I imagine that Sotomayor still thinks that Heller was wrongly decided, and it's because she accepted in Heller. Right. But I think they're like, we're not going to continue to relitigate Heller or even Bruen in every case. We're going to try to get the justices that we can who disagree with us on those fundamental questions over to seeing a route where the government might have more authority. Jackson
seemed willing to relitigate it, but that might just be because she wasn't on the court.
Yeah, maybe, yeah. She's like, I didn't get to say my piece yet, so maybe.
Yeah. All right. Well, so speaking of all this, what do you think the lower courts are going to do with this? Like, do you actually see the Fifth Circuit changing its approach to Bruen after this in any substantial way, or do we think you're going to continue to have these sort of circuit splits that we've seen, where the more and I don't even if you get that hypothetical anti-Rahimi case, would the Ninth Circuit pay close attention to it? What's the practical outcome going to be?
Yeah, I highly doubt that Rahimi will change how the Fifth Circuit or the Ninth Circuit adjudicates Second Amendment claims. There's enough in there for each of them, to say like, this is the way we always understood it. I do think there's one Ninth Circuit case, Doherty, about the felon in possession ban where the court strikes it down. I think the court there actually exhibits the same error as the Fifth Circuit because it's really uniquely focused on particular historical regulations. So that might be one case that changes as a result of Rahimi, or at least how the analysis is conducted. Maybe the court ends up reaching the same decision, but how the analysis is conducted. But yeah, I highly suspect that the Fifth Circuit's going to continue to say like these, there are no principles that support disarming domestic abusers, right? Like it's not going to say that in this exact case again, but they're going to say something like that. The Ninth Circuit's going to say, we've always looked at the historical principles, not particular laws. And so, we're going to pull it under that basis. It's possible the court could, refine it further in such a way that does tie the judge's hands in those circuits a little bit more. But at the end of the day, like it's impossible for the court to police all lower court activity. And so it has to take these cases like Rahimi that are kind of extreme outliers.
And, what do you expect in terms of the court's own workload on this front? I mean, they seem, at least some of them seem aware of this issue that they're going to probably need to take a lot more cases to flesh all this stuff out. You got that from at least three of the concurrences, right? Kavanaugh, Gorsuch, and Jackson, of all these unresolved questions that remain. And Kavanaugh kind of wrote a whole book about originalism as his his concurrence, but it ended with this whole idea of the infancy of Second Amendment litigation at the court, and so presumably he would want to take more. Like he talks about going slow, sure, but not like 10-year gap between each case. Kind of slow. It didn't seem like so. Do you expect them to take more cases, especially in this era where they aren't taking as many cases generally?
Yeah, I think the fact that they took Rahimi just 2 years after Bruen is a sign that they're not going to do the Heller wait 10 years again.
Well, they did take McDonald 2 years after Heller, right? And then they
did, but not on an application of a standard. Yeah.
Right.
And so, and there was a lot of reporting at the time that part of it was the squishiness of Justice Kennedy, and neither side knew exactly where he'd be on a lot of issues. I think the fact that there are 6 solid conservatives now is a little bit clearer on many of these issues of how they're going to rule, or at least general directions they might take. So I think that also means that we're likely to see more cases come up. I think the significance of the cases that are happening if there are the federal laws in particular, because they apply everywhere, in the felon in possession ban, in the government's filing after Rahimi, it said 12% of all federal criminal actions in fiscal year 2022 were this single law, right? And so I think the court can't allow like things like that to stand unresolved for too long. Like a year or two seems like already a really long time. Things like assault weapon bans, they have a huge kind of salience in the public, and they matter in particular states, obviously. But if Illinois enacts an assault weapons ban, it's just Illinois that's affected by that. And so that's kind of a different calculus from the Supreme Court's perspective on whether or not it needs to take that case immediately. Now, the thing about assault weapons bans is they're kind of similar to the May issue concealed carry, in that there's there's a small number of states who have similar laws. And so resolving an assault weapons ban for Illinois would also resolve it for all the other states that have it. So maybe that gives it a higher likelihood the court would hear a case like that. I think it's unlikely to hear ones that are only in particular or only a small number of states, like, insurance mandates, for instance, or like a butterfly knives ban. I think those are less likely to get the Supreme Court's attention. So I think we're more likely to get a case that's like an assault weapons ban, where it has lots of states are similar, and so you can resolve lots of things at once, or a federal law like 922G1, where the court is not going to want to let, especially a law that's frequently enforced, operate differently in Pennsylvania than it works in California.
Yeah, and we're recording this on Monday because it's a holiday week this week, and so we wanted to try and do this a little bit earlier, but we might get an answer to this, I guess, this week, because the court may. Do you have any insight perhaps on why they've I don't know they're kind of in purgatory, these Illinois cases, right? They haven't been relisted, but they haven't been denied. They're just kind of sitting around.
I think that's generally seen as a hold pending Rahimi.
Liminal space, right? That's
the liminal space where these petitions exist.
The phantom zone.
Yes. My best guess on those ones, is that they'll probably be sent back down for reconsideration in light of Rahimi. If the government is I guess one of the issues is that they're not at the stage the court would normally take a case like that. Is that that's my understanding of it. So I think there was a cert petition before the Seventh Circuit's ruling, but now the Seventh Circuit has ruled on it, and so I'm actually not sure. Maybe there hasn't been a petition filed yet.
But I think isn't it over the they want a preliminary injunction and they've been denied that, so they haven't gotten through the full trial.
Final judgment. Yeah, that might be right. Judgment.
So, but I guess we'll see. Right?
Yeah, so I think it's probably more unlikely they're going to take it until there's a final judgment on it.
Yeah. So, but we could get that before this comes out. If so, we'll talk about it in our news update. So make sure you guys check that out every week, and are always constantly listening to everything that the Reload produces and reading every word that I write. That's the most important takeaway. But look, I thank you for coming on and giving us your perspective on this. I really appreciate you doing that, because I like to try and give the audience,
thank you.
A wide variety of viewpoints from people who I think are serious on the topic. And you are certainly one of those people, even though you might have principal disagreements with David Kopel. I think you can both, you're both good voices on this, and it's important to hear from all sides so people can have a good understanding. They can take away what they think is the strongest argument or what have you. And then also, not everything, you guys didn't disagree on everything either. So that's another important point to.
Well, thanks for doing that, for having having lots of voices on.
Yeah. And look, we're, if you ever want to write in the Reload as well for an analysis piece, always welcome to do that too on these points. So we appreciate you taking the time to come and join us and give us your point of view. And hopefully we can have you on again in the future to talk more about this stuff, especially if and when the court takes up another Second Amendment case, which hopefully, and it feels like everyone's agreeing that they're going to do that more often, but we'll only know when the court does what it does. That's how it always goes, right?
Yeah, so that's right. But I'm sure it'll happen soon.
Hopefully, we'll see. But look, in the meantime, if people want to follow your writing or follow along with what you're working on, where can they do that?
Mostly on Twitter these days at Jacob D. Charles. That's my handle.
All right, wonderful. Well, I'm going to send it over to myself now to tell you guys a little bit about the Dispatch and why I'm a subscriber there, and they're a sponsor of this week's episode. So let's head to that. That's right. This episode is brought to you by the Dispatch. We're doing one of these classic promo swaps with them, actually on Kevin Williamson's newsletter, which is one that I personally subscribe to and read pretty much every time it comes out. I've actually been a paying subscriber to the Dispatch since they launched. They have over 400,000 readers now. Jonah Goldberg and Steve Hayes and Chris Steyerwalt and Ala Pundit. And there's so many people who write over there that I've long followed and respected and enjoyed their perspective. And of course, in addition to a lot of the great commentary that they have from people that you probably know better than me, the people who are more well-known than I, they also have a lot of really deep and original news reporting that they do. And so that's why I've been happy to have them as one of our sponsors, as a promo swap. I definitely stand behind their work and recommend it to you guys in a way that I couldn't say for a lot of other publications out there. So, if you're interested in checking out the Dispatch, if you haven't heard of it before, or you haven't taken the time to go over and examine what they're bringing into the world from a journalistic standpoint, I think you should do it. And in fact, part of our promo swap includes a 30-day free trial for their paid version. So you'll get access to everything they have for free for 30 days. So you can read it and make up your own mind. Just follow the link in the description here or in our newsletter this week at The Reload. So that honestly, I just do legitimately recommend them. And so I'm glad to do this sort of promo swap because they're one of my favorite publications. And I think you guys will enjoy them if you enjoy what we do here at The Reload. So check out the Dispatch today at the link in our description.
No, the devil's got no